Hello everyone. Welcome back to my channel USA Immigration and Visa. Today we are going to discuss about US visa for content creators and influencers. So let's start the video. For many successful content creators and online influencers, one of the perks of the job is the ability to work from almost anywhere in the world, including the USA. But before you can jump on a plane, you'll need to make sure you have the relevant permission for your intended plans, whether you're traveling to the US for a short business trip or planning a longer-term move. Without the correct permission, you risk running into problems with US immigration authorities, such as being detained at the border and denied entry, impacting future US immigration applications. In this video for content creators and online influencers, we take a look at the US visa options potentially available for you to work or carry out business-related activity while in the USA. First question that comes in mind is, do content creators and influencers need a visa for the US? When it comes to US visas for content creators and influencers, whether or not you will need a visa for the United States will all depend on the purpose of your visit and how long you are planning to stay. If you are planning a short-term business trip, for example for business meetings, you could travel as a visitor either under the ESTA or AB visitor visa. If you are looking for a longer-term move to live and work in the US, you would need to look at a work visa, such as the I-visa, O-1B visa, or EB-1A visa. Business trips to the US. There is nothing preventing online content creators and social media influencers from visiting the US for a short business trip, provided they do not propose to undertake any paid employment or paid performances while in the US, and they only plan to stay in the US for a maximum period of up to 6 months before departing. ESTA and visa-free business travel. If you intend to visit the US temporarily and have no plans to carry out paid-for employment, you may be eligible to travel visa-free if you are granted an ESTA. ESTA refers to the electronic system for travel authorization in the United States under the Visa Waiver Program, VWP. The VWP permits citizens of 40 countries to travel to the U.S. without a visa for the purposes of business or tourism for up to 90 days, provided they obtain travel authorization prior to boarding a U.S.-bound air or sea carrier at least 72 hours before departure. Depending on the nationality of the online content creator or social media influencer, this means that they might be eligible to visit the United States to carry out certain unpaid business activities under the VWP without having to apply for a visa. However, as with those coming to the U.S. on a visitor visa, the same prohibition against doing paid work applies equally to those who are able to travel under an ESTA. Anyone with ESTA authorization must also still request permission to enter the United States at a U.S. port of entry. This means that U.S. Customs and Border Protection officials must be satisfied that any visitor is seeking to enter the country solely to engage in permissible activities for no more than 90 days. As such, if a content creator or social media influencer arrives at a U.S. airport with the intention of undertaking work in the U.S., even if they only plan to do so for a period of less than 3 months, they may be refused entry. B-1 visitor visa for short-term business travel. Depending on your nationality, you may still need to apply for a B-1 business visitor visa in advance of travel, even if you are not coming to the U.S. to engage in any paid work. A B-1 visa is a non-immigrant visa to temporarily travel to the U.S. to engage in unpaid business activities of a commercial or professional nature, with an initial stay of up to a maximum of 6 months. To be eligible for a B-1 visitor visa, you must be able to show that 1. The purpose of your trip is to come to the U.S. for business of a legitimate nature. 2. You have sufficient funds to cover all their expenses during their stay. 3. You plan to stay in the U.S. for a limited period of time only. 4. You have a residence outside the U.S., and other binding ties, ensuring you will leave the U.S. by the end of your stay. For the successful applicant, a B-1 visitor visa will allow a content creator or influencer to come to the U.S. to undertake a number of permissible business activities, including negotiating contracts, consulting with business associates and/or attending meetings, conventions, or conferences. It could also include speaking engagements, provided no remuneration is received from a U.S. source, other than expenses incidental to the visit. However, the B1 visa will not be appropriate if you are looking to stay in the US for a period of more than 6 months. US work visas for content creators and influencers. In recognition of the importance of content creators and influencers to the marketing strategies of companies and organizations worldwide, and of the growing influence and demand of these high-profile individuals, U.S. immigration policy has begun acknowledging this type of work as a legitimate profession for authorized employment purposes. This is also now a recognized basis upon which an individual can apply for permanent residence. There are 3 main work visa options for online content creators and social media influencers: the O-1B visa, I-visa, and the EB-1A. O-1B visa. The O-1B visa is a non-immigrant work visa for non-US nationals with an extraordinary ability in various specialist areas, including in the arts. To qualify for an O-1B visa, an applicant must demonstrate extraordinary ability by sustained national and/or international acclaim, and must be coming to the United States on a temporary basis to continue work in their specialized area. This visa is a temporary but highly prestigious work visa designed only for the small percentage of people with extraordinary ability in their specialized field. However, for the elite few, this will allow the successful visa holder to work in the United States for a period of up to 3 years. They may also have the option to extend their stay in the U.S. in increments of up to 1 year at a time, with no limit on the number of extensions allowed. Due to the growing influence and demand for online content creators and social media influencers, this profession is now deemed worthy of approval under U.S. immigration law. However, for the successful grant of an O-1B visa, an applicant must be able to show a high level of achievement evidenced by a degree of skill and recognition substantially above that ordinarily encountered. This essentially means being able to show that they are prominent, renowned, leading or well-known in what they do on their chosen online platform. I-visa. The I-visa, Foreign Information Media, allows media representatives to enter the United States to disseminate information through blogs or social media platforms. The visa regulations have been adapted to recognize those who provide content through electronic media platforms. However, unlike the O-1B, the content must be newsworthy and informational in nature and cannot be used solely for a commercial or entertainment purpose. An influencer/content creator could cover a fashion event in NYC, for example, as long as they are not promoting a brand or any particular fashion or beauty product. Given the nature of influencers as marketers who can increase a company's brand exposure, this distinction could be a tough sell to the U.S. Embassy officer reviewing an application. However, if the project has a journalistic angle, i.e. a piece covering fashion trends for a foreign audience, the I-visa could be a consideration. EB-1A visa. As with the O-1B visa, the EB-1A visa again includes those with extraordinary ability in the arts through sustained national or international acclaim, including as an online content creator and social media influencer. However, the EB-1A visa is an immigrant visa, also known as a green card, granting permanent residency status to the successful applicant. As the EB-1A route provides a more permanent option for content creators and influencers interested in living and working in the United States, this route carries a much higher, extraordinary ability standard than the O-1B visa. It is therefore important for applicants to realistically evaluate their experience and accomplishments before applying. In some cases, given the slightly lower standard and quicker processing time for an O-1B visa, it may be worth applying for this non-immigrant visa first, before applying for a green card. In either case, content creators and influencers are strongly advised to consult with an experienced immigration attorney before applying for a talent visa or green card. That's all in this video. See you next time in another video.